My name is Mary Cheney. I am the owner and managing attorney of the law offices of Mary and Cheney, PLLC, better known as the Cybersecurity Law Firm of Texas, and welcome to the Breach Whisperer blog. In this blog, we will be talking about privacy and cybersecurity issues worldwide. For those of you that are familiar with my written blog, this is an extension of that or replacement for it, depending on my time and my ability to record or write blog posts. So, I mean, if you guys are interested in my previous works, if you can click on the link below, and it'll take you to my law firm website where the blog posts are there. Don't forget, speaking of links, don't forget to like and subscribe to our channel. So I know you guys are asking me why in the world or would we want to watch anything about cybersecurity and privacy. I mean, it can be highly technical, it can be full of acronyms, it could be legalese, it can be technical terms. And, because I feel like cybersecurity and privacy are not going away. And, I want to be able to share the knowledge that I have. I mean, in this video blog, we will be trying to educate the masses on cybersecurity and privacy. So, and things that you come across on a daily basis that you may not even think about that may affect you going forward. So, we will do this through articles, excerpts of speaking events that I may do, just basically any random things that I come across and find that I'm hitting record on certain things. I think that it's very important. I have a unique perspective. I think, based on my background, I could look at things from the cybersecurity perspective, the privacy perspective, it could be the hacker or the criminal perspective, the law enforcement or investigator perspective. It's so many different things that, are happening in cybersecurity and privacy that you guys may not think about. And being an owner of my own law practice, the things that come across my desk are amazing. So be warned, I may switch hats mid-sentence. And hopefully it's just to get you guys to think about things and in a different way. And please feel free to send me anything that you may find that you think I may find interesting. It may just make the blog, you never know. Caveat here, I'm a public speaker. I don't believe in too many edits. If I mess up, I mess up. So let's get started on your privacy and cybersecurity journey. Are you a VIP? More importantly, are you a cybersecurity law firm of Texas VIP? What's VIP, you may ask? VIP stands for Virtual Information Protection. For those organizations that may not need a full-time resource to handle their cybersecurity and privacy needs, they can hire the Cybersecurity Law Firm of Texas on an outsourced basis to handle those needs. If you want to learn more, please click the link below. Hello, everyone. I guess I couldn't have let this week go, this first week of January go, without talking about CCPA, the California Consumer Privacy Act, which went into effect January 1st. And I warn you now that I'm gonna get a little legalese on you guys today. So just bear with me, and hopefully you guys learn something I think is very important for technical folks who may be interested or who are interested in cybersecurity to also understand the privacy aspects of things, just so they can understand what's driving some of the activity in the laws, whether it be in cybersecurity or privacy. So CCPA became effective January 1st, although enforcement won't happen until July 1st. So organizations have this time frame, 6 months time frame, to get it together, so to speak, before the enforcement agencies out of California start to enforce it, because they have to come up with different rules of the road, rules of engagement, so to speak. Let's just say it that way. So you may be wondering, I'm sorry, California's act, of course, if you're not familiar with it, it gives private citizens in the state of California the right to know what's being collected about them and request that information not be sold, amongst other things. I'm not going to do a whole blog on CCPA. However, just understand that California's law is probably going to be the floor. when it comes to any future privacy legislation, even though the tech companies are trying to hack at the act itself, to reduce some protections, claiming that they can't comply or something of that nature. You see, I'm skeptical. I think that the tech industry itself, big tech, especially organizations that, like Facebook and Google and the bigger ones that routinely sell, and even the smaller ones that routinely sell. I think we're in a bad spot here in the United States in that we just routinely sell information about individuals over and over and over again just so we can sell them something. But that's neither here nor there. This blog would be like 40 minutes long if I started my rant about that piece. But what I want to talk about is why there doesn't seem to be, and there won't be, I don't think, any movement on privacy at the federal level this year. So the argument there are two different things that they're really, really, really arguing about, and one is called preemption. So preemption, and this is where we're going to get a little legal for you for a minute. You have federal laws, you have state laws. You have the federal constitution, you have state constitutions. There are certain things this country, as far as state sovereignty, allows states to enact provisions or laws that may be more restrictive than the federal law. Preemption says the federal law governs. Something like HIPAA, for instance. HIPAA preempts state law, which means HIPAA rules the law of the land, and states can't enact laws that are contrary to that rule, or to that law. And it's really interesting, HIPAA, and I'll get off on a small tangent real quick. And it's really interesting because what we're seeing right now is HIPAA is creating what's called a standard of care. So what's happening in the state courts, and some of them, I've seen some cases where people are suing based on the fact that an organization didn't meet their HIPAA requirements or they didn't follow the rule. And we're going to put a pin in it there because that may be a different blog and at a different time. But just understand that HIPAA preempts state laws. There are some state laws that can be more restrictive, like California's constitution is more restricted than the United States Constitution as far as citizens' rights, which is why you see a lot of legislation that are consumer specific coming out of California. So just that's the dynamic. So at the federal level, you have this, of course, bipartisan thought when it comes to preemption. Republicans are on one side of the House saying they want a national law. They want the national law to preempt all privacy laws, including California's, which is be interesting to see how they try to do that, seeming that California was first, unless they just make that the start of that legislation. And then Democrats, of course, don't want preemption. They want states to be able to enact laws that are more restrictive to protect their citizens. And so that's one thing to fight about. And then there's this fight about what's called a private right of action. So essentially, sorry about that, guys. My recording stopped as I was pontificating. I think we were talking about a private right of action. So a private right of action gives an individual citizens a right to sue based on violations of a particular law. And so, for instance, HIPAA does not have a private right of action, meaning you as an individual citizen can't sue if a hospital organization loses your data under HIPAA, meaning you can't bring a lawsuit under HIPAA. Now, whether or not you can bring a lawsuit for breach of contract, malpractice, or anything like that, or a failure to meet that standard of care is completely different. And the reason why the private right of action has been an issue or has summarily or lawsuits against organizations which have lost data, have data breaches, have not been successful in the past, had to do with the fact that individual citizens could not prove that they had any damages. You can't prove, for instance, that if a bank lost your credit card data, that you had any particular damage, which is, historically the knee-jerk reaction to all breaches is to give consumers some type of credit monitoring service. Well, years ago, I had the thought that eventually when organizations, it starts to come out that organizations are just really being plain negligent with your data. They're collecting your data and they're not doing anything to protect that data. For me, that's negligence. And for me, it doesn't matter if I can prove damages, so to speak, especially if it's personal data. If it's GPS, the location of my house, for instance, is different than my email address. My healthcare record is different than my credit card number. There's a distinction. I think there should be a distinction in the law for the different types of data that are being lost. And for that, a citizen should actually have a right, if it's personal data, that to sue, an organization that doesn't meet a particular standard of care. Again, I'll get off on a tangent. I've already been on a tangent on that. So the bipartisan issue with that is, Democrats want they want to be able to say a citizen has a right to sue. Republicans say they are against frivolous lawsuits, but there is a problem and something has to be done, and it has to benefit both the citizen as well as force companies to actually do what they say they're going to do. If they're going to collect your data, they should at least do something to protect that data. So, and that's what the FTC comes in and they enforce, like Equifax. They came in and enforced that, and they fined them and they put all these requirements on them, and and that's usually what happens. But the FTC itself is not the actual individual party that's been injured by some of these breaches. So we'll see. I think that those two issues, I think for me, the private right of action is important, just mainly because if an organization doesn't feel the pain, so to speak, and that's really what it is. It's, lawsuits are to feel the pain and to be able to incorporate corrective actions, because you even see with the FTC as well as with HHS and HIPAA, organizations get fined and they still don't do anything, and in hopes that it doesn't get found out again. So it'll be interesting to watch. I think the privacy professionals like myself are interested in seeing what's going to happen in New York, Washington, and Illinois, because we think that there's going to be some movement from a privacy perspective at the state law level in 2020 for those particular states. And I know, for instance, Texas is looking at that. And I believe, my opinion is, everybody's looking to see what's going to happen in California and how this is going to play out. Similar to, GDPR, they're just going to wait and see how the formal application of those laws happen in practice. And the longer the federal government takes to actually enact something, the more dug in, or the more they're going to not have the ability to stop some of these state laws that are out there. So it's interesting to see. Just like I said, be mindful that those things are out there. They will affect cybersecurity, and that the privacy laws, the data breach laws themselves are about cybersecurity breaches. Really, it's the loss of that data. So it's always been married, and we'll see what happens in this space. Thanks again. Have a great one. All right, let's say random thought for today. I saw this one, I thought it was interesting, and this is for you as an individual person. They're saying, or one of the things that I read in the article is about abbreviating 20 in 2020, right? So we often, when we write a check or when we sign documents or whatever, we'll abbreviate the year designation to 20. And this article was saying something to the effect of, it's easier for someone to commit fraud if you do like 1/4/20 as opposed to 1/4/2020, because if it's 1/4/20, then someone can add 2021, 22, 23 at the end of that to forge or potentially expose you guys to fraud. So my random thought for today is, for you personally, when you're signing official documents, if you sign documents anymore, which is questionable. I think I still write checks. I don't know if anybody else does out there, but if you do, Or if you're signing some mortgage statement, or you buy a house or a car or whatever, and you have all this information on it, or you're applying for a loan application, whatever it is, use the full year 2020 and not just 20. All right, thanks. Have a great day.